So Mr. Mitchell made mention of he made it 15 years. I think the court's well aware if he did that, that would be a downward departure. And I'll address that if they raise those concerns after they speak, Judge. In a situation that you had two defendants who did two very heinous crimes, it's a sad day when robbing someone at gunpoint isn't the main story, right? The main issue here was the first case, where on the early morning hours of October the 8th, this defendant, Mr. Reynolds, and his co-defendant, Ms. Natalie Fonseca, robbed Mr. Moreno Ochoa at gunpoint. And they did so in his own van. They robbed him at gunpoint, they beat him severely. And then when they got him to the top of the bridge, they told him it was going to be his last night on earth. They then took him out of that van, pulled him back by his hair, slit his throat, and together threw him over the bridge. And in my conversation with Mr. Moreno Ochoa, he told me, Mr. Longmire, once I hit that water, I thought I was dead. I grabbed my throat, and I swam to shore with one arm. And the body camera would show, and you saw the photos, where he was on shore at that Cumberland. He walked there, beaten, bloody, barefoot. He could barely stand. And it was just only by happenstance that law enforcement was there. Investigator Martinez walked the court through the tireless investigation that he conducted to identify both Ms. Fonseca and Mr. Reynolds. And throughout that investigation, right after this situation, if that wasn't enough, they then went out shortly a week later. And to be clear, Ms. Fonseca was at Circle K, and that's where, by happenstance, Mr. Sanchez is there. Having known Ms. Fonseca for approximately a year prior, he figured it was late, it was dark, he would be a kind individual and give her a ride home. And now, what Mr. Sanchez was saying to the court is when he went to pay at that gas station, that was when he pulled out money and even bought her a soda. It was at that time that Ms. Fonseca saw the amount of money he had, and that's why he believes once he got to the house, this defendant, Mr. Reynolds, then robbed him at gunpoint, Judge. So after throwing Mr. Moreno Ochoa off of the bridge, thinking he was dead, setting his van on fire, and thinking there was no other evidence, believing they were in the clear, they committed another robbery nearly a week later. And so then you have Ms. Fonseca who comes in here and says she is the victim. There was really no response I could give in that moment to such a blatant disrespect for the real victims in this case, Your Honor. Now, what is true is I do believe that because of Ms. Fonseca entering the plea, I think that was the impetus to Mr. Reynolds ultimately entering the plea. Now, as it relates to whether the court should give any concession to either defendant, the state would absolutely say no, Your Honor. Both of them deserve the maximum 30 years in state prison. You see, Judge, it may have been Mr. Reynolds who may have carried out that second robbery, but merely he was the way of Ms. Fonseca's will. Right? See, what I asked her was, without you, Ms. Fonseca, Mr. Sanchez never shows up at the house on October the 16th. She could not refute that. Without Ms. Fonseca, Mr. Moreno Ochoa never gets his throat sliced. You see, because he only met Mr. Reynolds in the demise of that night by way of meeting Ms. Fonseca. So it's the state's position that both of them are equally culpable in this crime, and they both deserve a maximum sentence. The concession was already given as it relates to their prior record, as well as their involvement when the state agreed to the cap of 30 years of state prison, and therefore the state would ask that the court impose 30 years state prison for Ms. Fonseca, as well as 30 years in state prison for Mr. Reynolds. We would ask that you impose a restitution. I think the court heard that both victims indicated that the money wasn't their main concern, but rather the trauma and fear inflicted upon them by both defendants, and they would rather incarceration than any restitution, Your Honor.
Do you have the specific amounts?
I believe I do, if my math was correct, Judge.
I didn't know whether they said 300 or 600 for Mr. Moreno Ochoa's cell phone. But if you have the figure, that would be great.
Yes, ma'am, Your Honor. For Mr. Moreno Ochoa, it would be $19,500. And then for Mr. Sanchez, it would be $3,250.
Let me ask, as far as Mr. Early Do you have any objection to those figures,
No objection, Your Honor.
Mr. Mitchell?
No.
All right. Anything further, Mr. Ballmeyer?
None at this time, Your Honor.
All right. Mr. Early, Ms. Ballmeyer, if you'll step back and let Mr. Early have table 1.
Your Honor, right off the bat, Ms. Fonseca entered a plea. She did so, she cooperated. Mr. Longmire has told the court that without her cooperation, it's more likely that with her cooperation that there was a concession and there was a plea in this case. Your Honor, Ms. Fonseca deserves a downward departure based on substantial assistance. He has acknowledged to the court that she was given substantial assistance, and that was a direct, that substantial assistance directly resulted in a plea in a case. Your Honor, why I think Ms. Fonseca deserves that downward departure is because she did get testified. She went and she faced 2 depositions. In her own sentencing hearing, she had to be attacked by the co-defendant and the state. But they still said, she gave depositions, she was here, she showed up, and that was the result of how that plea came about. Ms. Fonseca has taken responsibility for her actions. She got up on there and she said what happened, and she said that she took responsibility and she entered the plea. Not only did she enter the plea, she put herself at risk by cooperating against her co-defendant. And that information is going to follow her to state prison. Now, I know Mr. Longmire doesn't want her to get credit for that cooperation, but he admitted the cooperation happened. And when cooperation happens in a case like this, I think it's incumbent on the court to at least acknowledge and consider that in their sentencing of Ms. Fonseca. She has put herself at risk. That cooperation is going to follow this case. We're on TV right now. It's going out on YouTube or wherever it's going. And everybody got to see that she was a cooperating witness. And we're sentencing her. She deserves a downward departure for that cooperation. Now, I know that she's going to get a term of incarceration. But I would ask that that term of incarceration be minimal. 5 years, followed by 15 years of probation. But that's what I think would be beneficial in this case. I think that would be just. I think that would point out the fact that she cooperated, that she did go do 2 depositions, that she stood under fire. I took testimony from her knowing full well she was going to be under fire. She put herself at risk to get a conviction on Mr. Reynolds, and the state knows that. That's why they acknowledged it. So, Your Honor, I am asking for a downward departure, and that downward departure is based on substantial assistance that Mr. Longmire has admitted she gave. Thank you.
Judge, may I respond in turn instead of waiting until Mr. Mitchell?
You will, but just give me 1 minute.
Yes. Thank you, Judge. I just kind of want to put to bed this idea of this 2 depositions. What really happened is she said she was tired. So based upon that, I wasn't going to begin my questioning. So that's really why we went there twice. It wasn't like we did a depo, we went all through it, and she gave another depo. She did what any witness would do under the law, is gave a depo. As it relates to her substantial assistance, the assistance she gave, Judge, is exactly why she received the offer she received. Otherwise, I would be here asking the court for life after a jury convicted both of them. Now, so that's why she got the offer she got. So quite honestly, if she then received a downward departure based upon that, it would basically be a double dip. Now, that is within the court's discretion if that's what you choose to do, Your Honor. What I would also point out, as the court's well aware, when it comes to a downward departure, it's a 2-part analysis. Can the court do so? Should the court do so? Even to the extent that the court believes it can, the state would vehemently indicate or assert that the court certainly should not do so under these circumstances. Particularly when you have a defendant who says she is the victim. And it shows in this particular situation, she still does not fully understand her role in what almost took 2 individuals' lives, Your Honor. So I would ask that the court impose the full 30 years in state prison for Ms. Fonseca.
All right, Mr. Mitchell?
You have my promise that the plea in this case by Mr. Reynolds.
And do me a favor, you do speak low, and that microphone is better. If you will step back.
You want to hear, you go back here.
All right. The plea in this case had nothing to do with the depositions of Ms. Fonseca. I think the people that were in the room for the depositions of Ms. Fonseca will say that those were extensive wastes of time. What you got from Ms. Fonseca today is what we got in the room that day. A constant, absolute inability to, what is an important part of the reason for departure, which is acceptance of responsibility. She does not have that capacity. On the other hand, I suggest that what you found from Mr. Reynolds today was genuine acceptance of responsibility, was genuine thought about the horror that these two young people went through. Now, I'm not asking you to depart. You have the power to sentence Mr. Reynolds for 30 years. You have the power to go substantially below that. You ought to recognize that he did accept responsibility and offer genuine remorse as opposed to his co-defendants. And I urge you to give him credit for that, Judge. I appreciate your attention.
Mr. Lamar?
Mr. Reynolds was given consideration for entering a plea when I subsequently made him an offer of a cap of 30 years as well. So the idea, now I will agree with Mr. Mitchell, I do believe that Mr. Reynolds seemed to be more remorseful than Ms. Fonseca. But he too seems to lack a full understanding and appreciation for what took place in these cases. You heard him on the stand and he said, I made a mistake. A mistake which would be a big one would be if I showed up to court 5 minutes late. Cutting someone's throat, throwing them off of a bridge, setting their van on fire, and then robbing someone else at gunpoint a week later, that's not a mistake. That's done by an individual who does not deserve to be free in our society and deserves to be locked up for the maximum amount of time appropriate and allowed under the law. And based upon all of the facts and the circumstances in these cases, that's 30 years in state prison, and that is what the state is asking and imploring this court to do, to sentence Natalie Fonseca and Mr. Nafis Reynolds, each to 30 years in state prison. Nothing further.
All right, Mr. Early, Ms. Fonseca, if you want to come up to table 1, I will have Mr. Walmart step aside. All right. Considering that both of these defendants were originally facing multiple counts with the maximum of life, they both benefited from the sentence recommendation that was offered by the state. The crime that was committed, crimes that was committed against Mr. Moreno Ochoa are quite literally unfathomable. I cannot understand the fear that he must have felt when he was trying to be a kind individual. And I do see these two as equal in this. You know, there may be, again, there was an argument about a difference in remorse, but there are differences in this case. Mr. Reynolds comes before the court with, I believe, no priors, and Ms. Fonseca comes before the court with a prior felony and actually 3 prior felonies and a prior misdemeanor, and yet she is 7 years, I think, younger than Mr. Reynolds. So they've each got their own set of this is good and this is not as good. But when it comes to the events, the fact that this happened to Mr. Moreno Ochoa and then 1 week later to Mr. Sanchez is incredible. But the sheer violence of what happened to Mr. Moreno Ochoa is, I mean, in his letter to me, he said that Ms. Fonseca looked at him and said something along the lines of, "This is your last day to live." I cannot imagine the fear. He then said she grabbed his hair and pulled it backwards, and Mr. Reynolds slit his throat. And I believe it was 3 times. That, in and of itself, is enough to convince me to the sentence that I am going to sentence. First of all, I know that Mr. Mitchell did not ask for downward departure. Mr. Early did. Mr. Longmire is correct. It is a 2-step analysis. The one is, do they qualify? I quite frankly don't know under these circumstances if substantial assistance is a qualifier. But even if it was, I do not believe it would be appropriate. The sheer level of violence and the fact that there was another crime. And again, I know Ms. Fonseca wasn't the one that committed the second crime, but without her participation, it would not have occurred. And Mr. Mitchell didn't ask for downward departure, but the same analysis would go for Mr. Reynolds. I didn't hear any requests, I didn't hear any of the factors to analyze, but if there were this level of violence in 2 incredibly serious cases, I do not believe it would be appropriate. I do believe that both got the benefit of the bargain. The state offered it, they took it. Under the circumstances, it's going to be in both cases. Both cases, all counts as charged. It's going to be an adjudication on both cases, all counts as charged. Actually, I think that that is the way it is. Let me make a statement because I think the charges are the same except for when Mr. Reynolds pled, it was constructive. So the mandatory minimum that was there is not there. So now neither of them has a mandatory minimum. Is that correct, Mr. Longmire?
Yes, Your Honor.
Okay, I just wanted to make that, because what they are left with is the same exact charges.
Correct, Your Honor.
All right. For Ms. Fonseca, counts 1 and 2, 3, CF 4430, counts 1, 2, 3, and 4, 30 years state prison with credit for time served. Do you have that figure?
695 days.
695. 695 days time served. On counts 5 and 6, it would be 229.725 months state prison. And all of those are going to be concurrent and with the same credit.
I'm sorry, this is at 229.725.
Yet, month state prison, 229.725 month state prison. And in 24 CF 727, it is going to be 30 years state prison concurrent. Would it be 518?
Madam Clerk, yes, ma'am.
518. If there is any sort of an assistance fee, please assess it. There would be restitution, and it's going to be joint and several to Mr. Moreno Ochoa. $19,500. Again, joint and several with Mr. Reynolds. And to Mr. Sanchez, $3,250. Joint and several with Mr. Reynolds. And it will be reduced to civil lien. Did I miss anything, Mr. Longmire or Mr. Early, as it related to Ms. Fonseca?
Not to my knowledge, Your Honor.
$50 public defender fee.
Yeah, I ordered whatever assistance fee would be announced. All right, for Mr. I'm sorry,
Financials.
the due silly. All right, to Mr. Reynolds, on counts 1, 2, 3, and 4 of 23 CF 4430, 30 years state prison concurrent. In counts, it's all as, I'm sorry, counts 1, 2, 5, and 6 as charged. Counts 3 and 4, I guess I don't know whether that was amended. I don't know whether that's considered amended or just as charged. It's just, there is no constructive. Do you understand?
Yes.
Okay,
There's
thank
no
you.
actual position, it's constructive position.
All right. It's adjudication as charged. It will be all counts concurrent. And in 1, 2, 3, and 4, I already announced the 30 years. In counts 5 and 6, it would be 226.800 months state prison with credit for time served
$695.
of 695 days. $518 in court costs. If there is any sort of public defender or assistance fee, please assess it. It will be the same restitution. Again, for Mr. Ochoa, $19,500. Joint and several with Ms. Fonseca. To Mr. Sanchez, $3,250. Joint and several with Ms. Fonseca. And it will be reduced to civil liens. And in case number 24 CF 727, 30-year state adjudication as charged. Again, 30-year state prison concurrent. Is the credit the same in both cases, or is there a different credit for?
It would be, in both cases, they were picked up after the second case.
Okay,
And that's the new one.
so it's going to be, the credit is going to be the same. And Madam Clerk, I should have said this, the restitution to Mr. Sanchez is in case number 24 CF 727 in both cases. The restitution to Mr. Moreno Ochoa is in 23 CF 4430. Did I forget anything, Mr. Mitchell or Mr. Longmire in Mr. Reynolds' case?
No, Your Honor.
All right. You both have 30 days within which to appeal the sentence I just rendered. If you cannot report attorney, 1B24.
Thank you. Ma'am,